On. All right, so we are back in legal risk management. We've got Matt back on with us. Hi, Matt. Good to see you.
Hey, Chris. Happy New Year. Happy New Year to everybody else.
Yeah, Happy New Year to everybody. And we are back. We're sort of working our way through the book here. And we've talked so far about what is a risk in Chapter 1. And then Chapter 2, Matt gave us some insights into boardroom fundamentals and how we structure our board and their motto. And we've done that. And now we're on to sort of number 3, and we've got the slides up here today from Ernst & Young, and we're talking about legal risk fundamentals. Matt, start walking us through what do we need to know as an overview for legal risk fundamentals?
All right, thanks, Chris. And just as a health warning for all of Chris's students, he did think that this would be a bit boring, and I persuaded him that it was really important, because if you are going to be a practitioner, a legal risk practitioner, you need to understand some of the tools that you have at your disposal that you need to use to actually wrap your arms around legal risk, measure it, analyze it, report it, and make sure that people further up the food chain than you or I are actually aware of the good work that you're doing. So for me, it's one of the most important chapters of the book and contains some of the most important tool sets for me as a non-lawyer to actually identify, analyze, and report legal risks for my own company when I was in-house, and then for clients that I work with now. So for me, this is really important, and Chris is going to be converted in the next 40 minutes as well.
I'm excited to learn. Let's get started.
All right, do you want to flip over? So just start with a bit of a recap on the first and second chapter. So why legal risk is important, and then some of the trends that are affecting it. So just to skip through this, and you can read it on screen anyway, but it is a multi-billion-dollar problem. We generally underestimate the financial downside of getting legal risk wrong, because we look just at regulatory fines. If you look at the reputational impact, I know we've already spoken that it's up to 3. It's often 3 times greater than the fines. And then if you look at the actual cost of rectifying problems operationally, that will at least double the fines that you've got. So if we're estimating it at $100 billion a year, it's probably closer to $300, $400, $500 billion a year. The focus from regulators is putting it in the spotlight more and more. The big news in the UK is that we should hear from our financial services regulator in the next few weeks what their expectations are from in-house legal teams in financial services, and that will trickle through to other sectors in the UK, and I'm sure will make its way over to the US as well. We're expecting them to include legal risk as a general legal risk discipline, as a general risk management discipline, with the same requirements to evidence control as other risk management disciplines have. At the moment, management practices are very patchy. You have companies that have teams of up to 20 people working full-time, identifying, quantifying, managing, reporting legal risk for big global organizations. And on the other end of that scale, you've got companies that have got one person who's coming back from maternity leave part-time, spending a third of their time being the legal risk management for large international financial services firms. So hugely patchy management practices, and they have to there has to be greater consistency and a more consistent approach, and that's what these tools are designed to deliver for firms of all different sizes. I'm going to move to the next slide, Chris.
Okay, one quick question, Matt, before we move on. Are the regulators starting to consolidate and drive certain practices that you're seeing more and more a trend of in the UK? Or is it being driven by, say, you at Ernst & Young and others informing the regulators? How's that process going from the private sector to the public, or the public to the private?
I would love to say that I'm at the center of this and driving good practice around the world, but in all honesty, regulators look at the firms within their remit and look at areas of potential issue, and legal risk has come up consistently over the last 10 years, and most management practices of this type arise from regulatory queries.
Okay, great. Let's move on to slide there.
All right, so we've probably talked about this in one of the other lectures, but it's nice just to to revisit some of the visuals. So this is a set of slides. Oh, sorry, is that flashing up? Let me just get rid of that. I had an alert thing flashing up on my screen for a minute there. Sorry. Yeah. So 3 trends that I'm going to talk about just to help set the scene. Firstly, step change in regulator approach. The second one is going to be the increasing cost of litigation, and the third one will be that interest from regulators. So this chart here shows fines from UK and US regulators in financial services. 2 key things to note on here. So you've got value on the left-hand axis going up, and you've got time on the horizontal axis going across. It's all in pounds because I work in the UK and I convert all of the dollars to pounds because it makes it easier for me. And I'm making no excuses for that. Right, so it's all in pounds, but basically that highest one there, the 2013, that was $1 billion fine that the SEC imposed on HSBC. For money laundering Mexico as a high point. So two key things. You can see there are big peaks between, starting probably mid-2012, giant peaks around money laundering, around LIBOR between 2012, mid-2015, starting to die down a bit. I really wanted to update this before we did this chat, but I didn't have time today, I'm afraid. So it's starting to tail off a little bit. But the residual pattern is still, if you look at if you sort of close your eyes to those giant mountains, you can see the foothills of this chart. There are far more regular fines, and that fine level in the foothills is actually also significantly bigger than it used to be. So you can see that the maximum fines are massive. $1 billion is a lot of money for anybody, but in that foothills, it's changing from sort of 50,000, 60,000 to 3, 4, 5 million as an average fine level, which is a significant behavioral.
And it'd be interesting if one of the students wanted to do this, to go back and look at other periods when other financial crises happened back in the 90s or 2000s after the dot-com bubble crashed. My guess is regulatory fines went up then too, in similar sort of reactive natures after Enron or things of that nature, that the regulators in the U.S. probably had the same thing. So
I think looking at other sectors would be really interesting, actually.
Yeah.
Because the fine, or looking across other sectors, because they may not be quite as they might not be quite the same density. But some of the car manufacturing fines, environmentally related fines that were imposed on, was it BP?
Yeah.
And is it Kia, the car manufacturer? Yes. So stuff like that. It'd be really interesting to actually get a chart of regulator fines across different sectors to see how they have changed over the last 10 years as well, actually, to see if a similar behavioral element has crept into or is prominent in other sectors.
So if one of you wants to do that for us in the class, be sure to share that with me and Matt. We'd love to see your data that you get out of that.
We would do. All right, so significant change, behavioral change inducing fine levels that we're seeing in financial services now. So if you go to the next slide, the second trend is in that litigation costs. So 2 typical ways that legal risk results in loss is through that regulator fine that we've just seen, and then through litigation and costs related to litigation, either through managing it and through paying it out, legal fees. So there are some forms, and I can't remember for the life of me. Does it say on here? No, it doesn't. Form Y11K or something, that in the US, banks who are headquartered in the US have to fill in. And a couple of the fields in those forms are what are your legal fees and expenses, and litigation expenses. So being a bit boring, I put all those into a graph for a 5-year period and plotted them to see whether there were any trends. And what you can see is for the 4 banks that are on here, the scales are different. I think they used to be different. So there's billions. I may have balanced them out, but you can see that the litigation costs are very big, and also that there's no correlation between the litigation costs and the legal fees and expenses. So if you associate legal fees and expenses with the investment in an in-house legal team, you would expect that investment over a period of time to have an effect, a balancing effect on the amount of litigation. You can't control being sued for things, of course, and particularly where you are, but you can control you control what you do that may lead you to be sued by external parties, so you can control your own behavior. And if the in-house legal teams are doing their jobs well, and getting into the business and talking to them about where the risks are and about how to manage those, you would expect your amount of litigation, certainly the cost of that litigation, to fall. That's obviously not happening. There's no correlation for any of these 4 banks. So you can draw a broad conclusion that in-house legal teams should be exerting more control over litigation costs. There needs to be an investment for that to happen. So in-house legal teams need more resources, they need better tools, they need better understanding of the risks that they're managing, of course, in order to do that. But there's a clear message there, I think, that there's been a lack of investment in in-house legal over the last 5 years in the US for these 4 banks, and that needs to be increased if they're going to get their arms around legal risk.
Matt, if you look at these charts, though, I'm looking at the JP Morgan and the Bank of America, and you've got the legal, I'm sorry, have I got those right?
Maybe the dotted line is...
I'm sorry, those are litigation expenses. I've got those wrong. Yeah, I see the different charts. What would be interesting is to see for a division, all of these is basically flatlined legal expenses and legal fees. But It would be interesting to look at a couple of charts for others where maybe legal fees were declining and expenses. They weren't paying as many people. Did their litigation go up or come down where they actually had a decline or some change in their legal departments?
Yeah, you'll have a big time lag, I think. I reckon it takes a year or 2 for behaviours to actually change significantly and for that to filter through. Just from a behavioural perspective, and putting it on these charts, there's probably a bit more fluctuation than it looks like, but because the scale of the litigation litigation expenses is so big, it flattens out the legal investment. So,
and we're also assuming the legal team's actually handling the litigation here, aren't we? Because I don't know how it works in Britain, but in the U.S., a lot of times legal will just outsource this to a law firm, and the law firm is really where those expenses are handled, and the law firm bills the client for the litigation itself.
Yeah, I mean, you've got this in a later class, I think, but a good lawyer should be able to knock 30% off your overall legal fees, litigation expenses.
Yeah.
Anecdotally, from lawyers, that's what they reckon, and they reckon they're good lawyers, and that's what they think. But I'll believe them. So, 30% as a broad measure, if you can knock that off your litigation expenses, that's massive for these, based on these 4 charts. That's
yeah, sure, that's huge.
30% of $27 billion for JP Morgan.
Yeah,
that's
huge.
Yeah, massive. That's like $8 billion or something over 5 years.
Yeah.
But that's not the same as investing in a legal department to manage out behaviors that can lead to litigation, to manage out behaviors around contracting, for example, to make sure that you have binding contracts, that those contracts are being adhered to within your organization. It's not the same as employing people to do horizon scanning on legislation and regulation to make sure that they're aware of changes and are complying with them in advance. It's not the same as managing intellectual property to make sure that your brand is protected and that your staff who are customer facing know when they might be libeling customers or exposing the firm to additional risk. Your legal function is there to manage legal risk primarily, although they do that at the moment by advising on legal matters. Legal risk management requires them to do that on an aggregate basis, and that's what these tool sets are designed to help them to do, to identify risks on an aggregate basis, look at trends within the organization that leads to behaviors that can help them to put good controls in place to actually mitigate those risks, manage out the behaviors that lead to litigation or to regulatory fines.
Great. Should I move on?
Yeah, cool. So third trend. So regulators want the legal function to step up as a key risk function, really culminating in this FCA paper that came out end of last year now. the discussion paper that came out in 2016. But key events.
FCA is Financial Control Authority for Americans.
Financial Conduct Authority.
For Americans.
So, yeah, it is a truly behavioural regulator. It regulates conduct in financial services in the UK. I don't think there's anything else quite like it.
No, we don't quite have it.
The FSA, so the 2012 box, for those acronyms, FSA is a Financial Services Authority. And SIFI is Significant Financial Institutions. So they are financial institutions that are considered to be too big to fail in today's parlance. There was a kind of behind closed doors meeting in 2012 where they reminded GCs of their role in the second line of defence. And is there a line of defence slide in here? I'm not sure, but I'll cover that at some point. So second line of defence is really important because lawyers generally work in the first line. If you imagine there are 3 lines of defence against risk: first line, business, doing deals, customer facing staff, business people, operation, direct business operations. Second line, risk management, typically the risk management function, and third line would be internal audit. The risk management function should be joined. Basically, what the FSA was saying is that the legal department is a risk management function, and that they need to adopt risk management techniques in order to manage legal risk, which is a pretty fundamental change to the way most legal departments have. Certainly the way they were set up, because normally they're set up by the business hiring lawyers because it's cheaper to hire internally than it is to instruct externally.
Matt, is this going to be a regulatory mandate or just a guideline?
So where you put yourself in the second line, it's a bit of both. They say that you have to be in the second line. You say that you're in the second line. Do you exhibit the behaviours that are typically second line? That's here or there. I don't know. Most of the investigations, or all regulatory investigations, S166s they're called here, are behind closed doors things. So if you're involved in them, you can't talk about them, and if you're not involved in them, you therefore shouldn't hear about them. So who knows? But what's interesting is that now they are going to mandate it, I think. So they've mandated through the senior managers regime that we spoke about, and the senior insurance managers regime, that legal is a key risk control function.
Okay.
And it has to be managed by a senior manager. So it has to be managed by someone it has to be overseen, by someone who has a duty to report to regulators if anything's going wrong, and that have a legal duty to sort of sign off and say that risks are being managed well within that function, which is a step change which is that big step change in approach. In between that, ethical conduct's been put in scope of legal risk, and there have been the Prudential Regulatory Authority, that when the Financial Services Authority split, they became Prudential Regulatory Authority, that look after significant financial institutions, and FCA, which looks after conduct and regulates all other financial institutions. So the PRA were quizzing the firms that they regulate about their approach to legal risk as well. So very much on the regulatory agenda. I haven't got that amount of detail on the US side, but you do hear that it's also on the regulatory agenda in the US, and the SEC, Security Exchange Commission, appointed a compliance officer.
Yeah.
I don't think that's the right title, but somebody who is responsible for reviewing compliance frameworks within US firms to make sure, or to verify, that they are robust and delivering the required results. That is a step change, right? So It's not just, what are you doing, how are you doing it?
That's right. I mean, to some extent, that's actually becomes binding in that case, because SEC will make regulatory rulemaking authority over it. And as part of the audit process by the SEC, they'll make sure that companies are complying with it.
Yes. So big step change, both sides of the Atlantic, in FS regulation, and that filters through, and I keep saying this, but that filters through to other regulators, because the FS regulators have got all of the headlines and all the money and all of so anyway, that'll filter through to other sectors. Okay, so they're the 3 big trends: regulator fines, litigation costs, and the disconnect between investment in legal functions and those costs and then regulatory pressure to make legal part of the second line of defense. If that's going to happen, you need a good set of tools and you need a good proactive legal risk management framework. So if you just flip onto the next slide, which visualizes legal as a missing piece of the puzzle. So, operating legal risk as a proper risk discipline rather than just a subset of operational risk that just gets reported through and no one really worries about it too much. Cool. So next slide. Right. So the legal risk management framework. What I'm not going to do. Well, should I tell you what I'm not going to do first? I am now anyway. So
that's fine.
What I'm not going to do is go through COSO and then go through ISO and go through all the different risk frameworks. I'm just going to go into our blend of those, which is kind of picks the best of both those frameworks. So they're both operational risk management frameworks that we've adapted to create our approach.
And we talked about those back in chapter 1 to some extent anyway when we were doing that. I think we talked about COSO and ISO. We did.
Chapter 3.
Yeah.
Chapter 3. Yeah.
You and I, when we had our discussion about chapter 1, didn't we cover some of that? Or what is a risk? I thought we did. Anyway, okay. Well,
I'll say yeah, but we didn't cover the different frameworks. But I don't think anyone needs to go into that amount of detail. I'll be on your side of the fence if we get into that amount of detail on this.
All right. Let's go on to look at the 5-step framework here that we talk about in chapter 3 on this.
All right. Cool. So this is deliberately designed to be as simple as it can possibly be. The 5 steps, I'll read them out, but you can see them on the screen. Identify, analyze, evaluate, treat, and review. Before you can, if you're going to manage anything, you need to know what it is, which is why you need to identify it. You need to know what the impact of it is on your business, the negative impact of it is on your business, or the positive, so that you know whether you need to manage it or not. You need to be able to evaluate risks across different disciplines so you can prioritize legal risk against operational risk or credit risk or market risk or any other of the risks that you manage. You need to have plans. Once you've identified something that you need to manage, you need to have a plan in place to reduce it, to avoid it, or to reduce it or to avoid it altogether, so that you can continue to operate your business without fear of your business being subject to $1 billion fine. And you need to review what you're doing consistently and monitor the controls that you put in place to treat your risk, to make sure that they are effective, or to verify that they're effective, and to make improvements, because the world that we operate in changes on a very regular basis, and a business needs to be able to adapt to that. The only way to adapt to that is to get constant feedback as to whether what you're doing, how what you're doing, it reacts to the external environment. In this case, we're talking about legal environment, but you need to be able to review that stuff. So, I think next slide. So to identify it, you need to define it. We've done defining in some detail, so this is going to be just a very quick recap of how we approach our definitions. And we did do this, didn't we, in our first lecture, Chris? I
think it's worthwhile to come back and talk that again. I wanted, if we could go back one step, Matt, here at the end, because we use a couple of acronyms here, and I wanted the students to be able to recognize this from the book. We talk in step 5 about review and KRIs. Could you talk a little bit about KPIs and KRIs, what they're for, why we need them, and what ultimately we're looking for? I think you have it in later slides here, so I don't want to jump the gun if you're going to come to it. But
you are jumping the gun.
Okay, then we'll let.
So a KRI is a key risk indicator, and it is very important in helping you to stay alive to changes in how changes in the environment are interacting with the way that you operate, to see whether your risk levels are rising to a level where you need to take action. Okay. Well, I've got some example KRIs around conduct risk later on. So first step, you've got to know what you're talking about. You've got to know what you're identifying. So you need to have a definition of legal risk that identifies the form of loss that you're trying to avoid. So financial reputational loss in this example on the left-hand side on the policy definition. How that could arise. So we describe it as an abstract description of how it could arise to tie it into behaviors. So a lack of awareness, failure to understand, reckless indifference are 3 behavioral things that that could lead to that risk being realized. Ambiguities in the way the laws and regulations apply to a business is separate to behavioral. You need a behavioral to control that, but the fact that the law isn't always consistent and isn't always consistently applied needs to be dealt with slightly differently. And the scope of that business, products, services, practices, so you know where the limits are to your risk management process. That policy level definition is deliberately behavioral, and that's because it needs to reflect the fact that legal risks do result from decisions people make, actions that people take, and therefore your policy definition needs to have elements of human behavior in it if you're going to be effective at managing it later down the line. We don't talk about legal risk just as the law. You need to see how the law interacts with an organization and our taxonomy that we've been through already. Legislation, regulation, pillar 1, contractual risk, pillar 2, non-contractual rights, pillar 3, non-contractual obligations, pillar 4, and disputes, pillar 5. What do you call non-contractual obligations? Non-contractual obligations, torts?
Oh, yeah, torts, I guess you would call it.
It arises from torts. Actually, it's federal law, and you're common law, aren't you?
Yeah, we are common law.
Yeah. So it's pretty much the same, unless you're in Texas.
When it's all a tort.
All right. So there's key interactions. So you can see, I think, how legislation and regulation interacts with a business, and you can physically see how a contract interacts with a business. So they're quite clear boundaries. And it's really important to have clear boundaries to your analysis exercise, so that if you're in a meeting with people and you're talking about legal risk, they don't start going off saying, "Oh, well, what do you mean?" You say, "Okay, we're talking about legislation and regulation. What legislation and regulation applies to your business?" If they don't have an answer, they've got a risk. If they do have an answer, you can go and check that to see whether you think that's the right answer and see whether there's a gap that results in a real risk. Same for contracts, non-contract contracts. Where are your contracts is a typical question. How do you stay aware of changes to contractual obligations that you make over the phone instead of writing them into a contract? There are lots of questions you can ask to see whether business practices are resulting in risks or not. And that leads to a more detailed, practical, working definition, which we've got on the right-hand side of this slide. That calls out some examples for each of those pillars. So failure to adequately comply, inadequacies in contractual relationships, failure to manage, failure to respect others' IP, understanding non-contractual obligations, mismanaging legal disputes, key sort of things that help you to then tie operational procedures and changes to, and if you've got a good thing to tie those changes to, you can then show and record the effect you're having on overall legal risk profiles. All right, so can we do the next slide? So this is just another way of representing that, but it shows that where you have these 5 pillars, the blue lines cutting across the bottom represent different business lines. So you look within each pillar across each business line. And I spend quite a lot of my time in workshops with people talking about in depth through each of these pillars. How does this apply to your business? What do you do in your business? And how do you, where do you enter into contracts? What IP do you manage? Who deals with disputes? What's the procedure if somebody wants to sue your company? Because that gives me very good answers to start to look at where the actual risks are. So if you go to the next one, it's that taxonomy. So you've got the 5 pillars on the left-hand side, and then we get into the more detailed. You can't see me pointing at the screen, can you? I should have one of those laser pointers.
I think I can. Do you see my pointer here?
Oh yeah, you're moving. Yeah.
Yeah. Where do you want?
So it's like 1.1, failure to adequately comply, 1.2, correctly assess. So each of those line items goes into a register, and it's actually more interesting than it sounds, having conversations with in-house teams, with business people, with operational risk people. Okay, so how would this risk be instantiated? How would this risk occur in your company? What controls do you have in place to prevent it from occurring? And go through that line by line. So if you go to the next one.
Next slide.
Yep. So this is sort of an example of what we pump out from those meetings and workshops. So going through that taxonomy line by line, you put narratives around, and I'll talk through the different columns of this. It's probably too small for me to read, but I think I can remember it. So you talk through it, so you put narratives about how it could apply to a specific business, and then you start to rate the impact of that risk should it go wrong. So I'll talk you through these different columns first, and then we'll talk about that impact analysis, because that's the second stage of the risk management process, is that analysis of the impact of the risks. So we have got on the left-hand column is a reference number, and then we've got office, office, business line. So basically something that ties it to a geography. Because you might want to report by country what the different risk profiles are. Something that ties it to a business unit, because at the end of the day, you need somebody who runs a business unit to decide that this is important to make a change. And you'll see a report that brings this to life, heads of business, a bit later on. You've got the top level, so the fourth column along is the top level legal risk categories. So on here, they're mainly contractual. Second level is so the fifth column is that second level of the taxonomy, where we flesh out the details. The 1, 2, 3, 4, 5, sixth column is the narrative. So company specific narrative around how that risk can apply to that business, something that will bring it to life to operational staff. And then 1, 2, 3, 4, 6, 7, 8, 9 are all ratings for 7, 8, 9, and 10 are all rating analysis ratings. So the way that we analyze risks, we've identified them. We've got a big list of risks, and the fact that it's a spreadsheet that's got colors just shows that I've worked with clever people that can make spreadsheets change color. So the way you analyze the impact of this risk is in typical and extreme scenarios. So there are lots of really bad ways of analyzing the impact of a risk. Most of them involve a matrix, 5 by 5, 7 by 7. Some of the really bad ones involve deciding whether an event could happen once a year, once in 1 year, once in 5 years, once in 50 years, or once in 100 years. I don't know anybody that can actually put their hand up and say, I can definitely say that this is a 1 in 100 year event. There's a lot of evidence out there that we're very bad as human beings at predicting how frequent serious events are.
Or the magnitude of them, for that matter.
Or the magnitude of them. So that's a very bad way of analysing risk. The best way that I've found in the world, the way that I prefer, is to look at two scenarios that simplify that. Is it a 1 in 100 year, or is it a 1 in 1 year? Typical scenario, what you expect to happen based on your knowledge of the way the business operates, and previous losses, things that are coming in the next 12 months. That's your typical loss. And then everything else is extreme. You don't know whether an extreme event is going to happen tomorrow, or whether it's going to happen in 5 years or 50 years or 100 years. And I don't believe anybody that says they can predict to that level of accuracy. So instead of doing that, you just say, right, everything that you don't know about is a potential extreme event. What's the worst plausible thing that could happen? Not the worst possible, because the worst possible thing could be, anything could be possible. So it takes you out.
A meteorite hits the Earth, or atomic war starts, or something like that.
Yeah, it's possible, but so unlikely as to be implausible, and therefore we don't consider it. So the worst plausible thing that could happen, and then you analyze the financial impact in both scenarios. So what would you expect to lose in the next 12 months because of this risk? And then in the extreme scenario, what's the worst plausible loss that you can think of that could happen were this risk to be realized, were there to be a complete control failure? A plausible control failure, sorry, because I have actually fallen foul of complete control failures before, and you end up with 500 million exposures that actually aren't plausible because of the level of investment in the control environment. So plausible.
Is there an example you could give us of something like that?
So if you look at Bribery Act, for example, it's an unlimited fine for for breaches of the UK Bribery Act. It applies in the US as well. You could equate it to the Foreign Corrupt Practices Act. Unlimited fines. So you could estimate that fine at a level at being, for the Bribery Act anyway, for let's say £100 million. So what's that? Probably $110 million nowadays, but $150 million. But if you've invested in compliance in Bribery Act compliance for 5 years, if you've trained all of your staff, if you've made everybody aware of their obligations, if you've done everything possible to create an adequate defence to make sure that if anybody breaches the UK Bribery Act, it's on their own head in full knowledge of the consequences, you fall into a different fine category. So you would fall from a 50 million fine down into a 5 million fine, for example. And there's the FCA have actually got have got an actual handbook, a fine handbook for the Bribery Act that will tell you what category you come into depending on what they find if they do an investigation. So your investment in your control environment has a significant effect on the fines that will be imposed on you. And it's implausible to believe that 5 years of investment in a control environment just suddenly disappears. Can't happen. It just can't happen. So you might get a few rogue execs going off trying to hit their bonuses, but that should be, sporadic practices, reckless indifference to law and regulation in full knowledge of all the consequences. So that's the example that I had basically. So you end up with a set of financial values for loss, and they are compared against a threshold. You also end up, because we're not looking just at direct financial loss, although that's the one that gets people's attention at a management level if you start putting dollar values against things. But you also need to assess the indirect impact, which is where we look at the reputational side of things. So it's basically a table that you have, because it's impossible to predict the financial impact. So you look at the raised headlines, for example, on a scale of 1 to 4. So would there be local headlines relating to a particular breach, or would there be widespread and consistent headlines across the world telling everybody what you've done, and that could lead to customers leaving and to heightened regulatory attention on your organization? So you have a matrix that measures indirect ratings that comes up with a number, so a number between 1 and 4. So you end up with a number between 1 and 4 for reputational impact, and your financial values get compared to thresholds. So you decide what is low, medium, high, and severe in terms of financial loss for your organization, and you compare your estimates of loss against those numbers to come up with a number, what a threshold, 1, 2, 3, or 4. You do that because if you just give people a threshold value, they'll say, well, I want it to be a 3. So they look at the 3 before they decide that that's 50 million. What you want them to do is have a thought of what the actual value is, to get rid of all those biases and heuristics and subjective comparisons. If your risk is a 3, mine can't be a 4. So okay, what's the typical loss? What's the worst loss? And then compare that against threshold. Let the spreadsheet pump out the final rating.
Yeah.
You take. So you effectively have 4 numbers: a typical, 2 numbers for typical, 2 numbers for extreme. You take the worst of all of those numbers, and that becomes your overall risk rating. Because if you took the best, you would be ignoring all of the high-end risks. So you take the worst of those risk ratings, and you end up with, in this, green, light yellow, and dark yellow or orange, and then there's obviously a red for where you get really bad risks coming through. So that's how the analysis ties onto the identification. Once you've identified your risk, you then analyze the impact, and that gives you a set of values that you can then use to evaluate those risks against other risks in the organization. Because legal risk might not be that big a deal, right? Depending on where you work, it might be nothing compared to market risk or compared to operational risk. Business continuity might be the big thing. So you need to be able to look at the values for legal risk at a level playing field to other risks in the organization, so that if they are top 3 in the organization, they get the investment and they get the time devoted to them to mitigate them and to bring that exposure level down, to make the organization more robust. Okay, next slide. doing the reports in that level of granularity, so doing that analysis to that level of granularity, enables you to start pumping out quite good reports that when management start to inquire as to, and you start to ask well, why is this 45 million exposure? Where does it come from? And you want to be able to give them an answer. So actually on this chart anyway, it's exposure not entering into a binding agreement, and consequences result from amendment or waiver to contractual rights, so that they're behavioural, right? That's people entering into contracts, entering into agreements without a contract, or doing business without a contract, and people amending contracts without telling anybody in the operational side. So they're behavioural things that you can start to think about how to put controls around that, and you can tie that effort to make a control against the value of £17 million. So just gives you a good way of reporting. You can also compare typical versus extreme. So you see here we've got £0 exposure for typical. So you would expect somebody with a profile like this to be very well run, aware of potential extreme scenarios, and therefore if they decide to invest in controls, they're investing in bringing that extreme scenario exposure down, trying to again make the organization more robust.
And the number of risks here tracks back to the register and the different line items in the register.
Yeah, just a simple count, just to help to see, okay, it's just another metric that may have meaning to some. It's useful to see, if you've got 42 risks, that results to 45. If you've got 10 risks in another category, that's 12. Is that roughly equivalent? Yeah, it just helps you to see whether non-contractual obligations risk would probably be biggest. I don't think we've got an example, because that would put you into conduct risk categories, so that you would probably have a higher per risk value in that conduct risk category than others. But it's just another interesting stat that you can put together and start to make things out of it in reports. So next slide. Another set of reports, more visual this time. So reporting by risk pillar. So the topmost, the one that's behind, chart that's behind the other one, the overall contracts are our biggest source of potential loss. That just shows where our where the loss is coming from. So that'll be the sum of typical and extreme loss. And for this organization, or for this type of organization, contracts are the biggest risk. A lot of organizations, legislative regulatory risk is the biggest one, but it depends the size of the organization and the sector that they're in.
And of course,
and the other one
fluctuate over time too. Even for the same company, these bars would move probably continuously to some extent for different companies.
You would hope not. I think you would hope it would move down. You wouldn't expect it to start to move up and down. I think you have a kind of some businesses are inherently riskier than others. And some types of business are inherently riskier than others. I don't know if that's exactly the same thing. It probably is. But you would expect a structured trade commodity finance business, which is what STCF stands for, to be inherently more risky than private banking.
Right. That makes sense.
And that risk exposure, relative to the earnings of that business, you would probably expect your structured trade commodity finance business to make 20 times more than your private banking business as well. So although it looks really risky, you need to keep in mind that it probably brings in enough money to balance that risk out.
Yeah.
Having said that, if you can bring that legal risk profile down, you can take money, you can take money out of a risk regulatory risk bucket and put it into a capital you can reutilize bucket and start to help to drive business growth moving forward.
So that's actually, it raises one interesting thought in my mind, Matt, which is the old adage goes, no risk, no reward. And if I'm trying to bring down my risk levels for a company, am I potentially, yes, I'm going to protect against fines or tort litigation or so forth, but am I potentially compromising profit lines by doing so, by being more conservative overall, so that my gross revenues go down?
Well, you do it within a risk appetite, and you have different strategies for typical and extreme risk management. If you've got a high typical loss, and I've worked with one company in the last 5 years where they had a bigger typical loss than Extreme because they'd had a lot of issues, and they'd put a lot of robust controls in place, so they weren't expecting any repeat, but they were still dealing with the fallout from the previous few years. So they were leaking money because of poor legal risk management. You manage that typical. If you are leaking money, if you've got a lot of contract risk, a lot of contracting behaviour that leads to contractual disputes that cost you profit, you want to minimise that as best you can. So you manage that. If you've got a lot of extreme risks that could wipe you out, you want to make sure that you're investing in controls to minimise the likelihood, or to reduce the likelihood of actually being wiped out, to build a greater level of robustness into your business model, rather than just hoping, because nothing has ever happened before, that nothing's going to happen in the future. It's about being proactive, looking at the behaviors that you exhibit that could lead to something happening. Or what were you saying to me before? Making sure that you're a cat, not a vase.
Yeah.
Making sure that if you fall from a great height, you're not going to smash into a million pieces. You'll be able to land elegantly and then carry on your merry way. So
yeah.
That's the end game of it.
Yeah.
Let's move on to the next slide.
Sure.
And then these another example of the reports that you can pump out. So extreme versus typical risk maps. And you want your typical risk map to be green. You don't want to be leaking money through legal risk. You want it to be well managed. You want to show that as a legal department, you've got your hand on everything that's going. You've got your arms around everything that's happening day to day. I've seen ones that are far worse than that. And on the extreme risk map, again, you want to show that given the investment that you have in your controls, plausible control failure is limited and is limiting the scope of impact of the event. So you may not be a cat, but you might be a really, really well-made vase. Might be a rubber vase.
Or a cardboard box or something that doesn't
different kind of fragile cardboard boxes. But yeah. All right, so let's move on.
Just a quick question here.
Yep.
What are the small boxes here in relation to the big one?
All right, yeah, good question. So I should have explained these. So on the left, so the columns are risk pillars. So you've got contractual, legislative, regulatory. They're the 5 risk pillars. The little squares are coloured where there's a risk. The colour relates to the rating. So green is 1, yellow is 2, orange is 3, red is 4. 1 being low risk, 4 being high risk. And then the big coloured boxes on the left are the worst of the little boxes. So what it means is that you can read down a column to see whether you've got an issue with contractual risk across all business lines, or legislative risk across all business lines. So you can see whether there's an issue with a particular area of legal risk, or you can read across a business line to see whether a business line has issues across all risk areas, which is a different set of behaviours that you need to start to look at.
Sure.
So it just helps you to pinpoint where you need to take action, or where you can take the most effective action to bring your overall risk profile down.
Makes sense.
Okay, controls. So we have identified risks, we've analysed their impact, we've evaluated them against other risk categories, and we've done some really cool reports to show to people up the line, this is what the risk exposure looks like. Now, when you start to talk about controls and treatment, I mean, that's really what the rest of your course is about, I think. Certainly from the book perspective, 4 to 8 are all about different methods of controlling risks within each of those risk pillars. From an organizational perspective, you have to be looking at putting controls in place to manage the risks that you've identified. Otherwise, there's really no point identifying them at all. All you're doing is saying, look, we've got a really bad risk profile and we're happy with it. So what this slide is trying to show is that those controls, the solutions you put in place to manage legal risk, have an impact across the organization beyond there being just a report to management. So you can put in place, if I go clockwise, you can conduct indicators to inform management
We're
So top right.
top right. Yep.
Clockwise from top right. So we've got, I mean, the blue ring is business line, and the outer ring is geographies, just to show the sort of scope going across the organization. But conduct indicators, which you can input to conduct risk teams or to frontline businesses to show them where, and there's an example of this a bit later on, where key legal risks, if you've got risks in certain legal risk categories, they indicate that you could have a conduct issue that could result in a much bigger problem. So it gives you an area to look at or to test whether that's actually the case. Contract analytics. If you look at contract risk, next one around, that can give you data and metrics and indicators that can tell you whether you've got good or bad contract management behavior in different parts of the organization, so that you can start to go and address operational practices, operating behaviors in different parts of the organization to improve the way contracts are managed and reduce your exposure to contractual dispute. Control augmentation all the way throughout the organization. So because legal risk does overlap with other risk categories, it also overlaps with other control areas. One key thing that I think gets missed from operational risk is the use of a contract as an operational risk control mechanism. So if you are improving your contracts and the way your contracts are managed, you are also improving your the way that you manage operational risk, because contracts are designed to manage operational risk. Capital models, the requirements are changing, but you used to, legal risk would need to be the changes recently, but you used to have to report legal risk, and it was going to need to be calculated in operational risk models. I think that requirement is not my specialist area, I've got to admit, but I'm pretty sure that requirement is being removed in favour of a different way of modelling. Risk control self-assessments, so quantitative risk analysis into risk control self-assessments that happen throughout the organisation. So businesses have to self-assess around different risk types. So putting in place good legal risk self-assessment tools like that risk register that we just looked at, help to manage risks throughout the organization. And then supervisory control frameworks are basically the set of sort of accountabilities, role profiles, governance structure, the things that every department and every business does to manage risks within its remit. Because legal risk overlaps with other areas, there are controls that you would put into other functions, supervisory control frameworks. So if you take HR as an example, so the general counsel, the head of the legal department would have legislative regulatory risk in his bucket. There would be an overlap with HR, because HR have to stay aware of legislative regulatory risk related to employee matters, and he may outsource his management of legislative, his horizon scanning activities for employment law to the head of HR, and that goes into their supervisory control framework. He might keep a monitoring role towards that. Does that make sense?
Yeah, it does. Absolutely.
Good. Cool. So that's sort of how those controls spread throughout the organization to show that legal risk management isn't just an isolated activity, it actually has an impact on other areas. If you go to the next slide. So remember I said, if you're the head of a business, you need to get ahead of a business to decide that they need to take an action, because they're going to need to make an investment in improving a control environment, either of time or of money. So when you review controls, you can basically assess whether they're good or bad. You give them a rating: effective, ineffective, or needs improvement. Effective being the green boxes on this report, ineffective being red, and needs improvement being yellow or orange. So it's sort of a summary of that register that has the legal risk, has a description of that risk, the narrative, the business specific narrative, so the head of that business can see how this is a risk to them. It's got the typical direct value, because heads of business will care about money, and it's got the typical it's got the extreme direct value, impact value. So it can show there's a potential on the top line, there's a potential £2 million exposure, and there's an ineffective control, and you can assume that improving the control environment reduces the likelihood of reduces the impact of a plausible control failure, and therefore brings that exposure down. So if you're adding up your extreme risk exposures, you can start to have a good impact on that by investing in these control environments.
Mm-hmm.
If this showed some typical losses, it might be you might be able to shave $500,000 a year off some particular business lines just by improving some of the controls around payment terms in contracts, that kind of thing. So that's that sort of business specific report. To bring the control work to life. What's the next slide? What's the next one? So yeah, this is the sort of overlap with conduct and the correlation between legal risk and conduct risk. And it's quite a complicated map, and I'm really not going to go through it. But basically, certain of the legal risk second level categories in the taxonomy. So can I read them out? Let me see if I've got it on my hard copy, and I'll read a couple out. All right. So, for example, infringement of third-party intellectual property rights. If you are infringing other people's intellectual property rights, that could be indicative of a conduct issue. If you are failing to enter into binding agreements, that could be indicative of a conduct issue because you're not taking the need for legal contracts seriously enough. So there are certain risks on the left that correlate to conduct issues, and this is a way of calculating that correlation and then reporting it back. So the orange, purple, and red boxes are all correlation factors. They add up to numbers and then they get written back. So you basically calculate how much of your legal risk exposure is related to conduct risk. It's a bit complicated, but it does make some sort of sense. And it's quite a cool way for lawyers to start to input into conduct risk conversations. Say, well, from our legal risk analysis, we think you need to look at that area there where you've got an extreme orange, because that could be somewhere where business behaviors could lead to a conduct issue. Okay. It's just a useful way of pinpointing things that you might need to do in the future. Right, next slide. Cool, we're done. Key points.
All right.
So obviously the key point being Chris was wrong, and this is really exciting thing to learn about. But
I never said it wasn't. I just said I was incapable of explaining it in an exciting way.
just to recap, so multi-billion-dollar problem. Legal risk management is a core risk discipline. We saw that from the regulatory fines, from the litigation expenses, all of that stuff we talked about different regulators. You need to be able to articulate what legal risk is if you're going to manage it. You need to quantify the potential loss if you're going to get people to buy into legal risk controls. Really, I mean, it's probably the key point. The key point that people struggle with is, how do I quantify what my legal risk exposure is? Because if you don't quantify it, you're not going to get a business case passed by by the people who hold the purse strings.
And that's where the KPIs and the KRIs come in here to some extent.
Yeah, so those conduct maps, those reports we were talking about, it's all about what data, what reports, what data do I have that gives me evidence that I have an exposure that I can manage, and how can I manage it? So I've got potential 5 million loss. It's going to cost me 50,000 to fix it. That 50,000 is going to reduce my potential loss to 1 million. That makes a return. That's a good investment.
Yeah.
And it helps you to persuade people to invest in good legal spend rather than bad. So good legal spend is investing in proactive procedure, proactive controls that reduce impact to litigation, that reduce impact to heightened regulatory pressure, reduce potential reputational negative reputational outcomes. That's good legal
spend. The light bulb just went on, and it's exactly what you're saying, which is you have to quantify, in part because you're asking people to spend money up front on something preventative. And by doing so, most people are reluctant to spend. That's just human nature until the crisis has already hit. And
yes.
So that by showing them that offset of here's how much you're going to offset, you're in a way creating a very persuasive model by which people will actually put that capital outlay up front.
Yeah, And it's not sneaky or any. It's how everybody else does it. It's how all of the other risk management teams, all the other second line teams, do that. The only second line of defence that don't do that at the moment is legal, for a wide variety of reasons. And that's the key thing that we always try and get across. It's quantify your loss. Put together a business case that you can put in front of a steering committee, you can put in front of your board, and they'll buy into what you want to do. Because no in-house legal team wants to spend their life in an ever-increasing maelstrom of regulatory demands, of litigation to deal with, of business asking why things have gone wrong, at the same time as being questions, why do you cost so much? Because you're qualified lawyers. It's hard to be an in-house lawyer, and they need tools to help them to manage that, and to get people. The only way to manage that increasing workload, which is so big now that you can't do it just by working harder, which is the typical solution, and because of the pressures on cost, you can't just hire more people, and there's only so much you can push external legal spend down. So it's about making sure that you can actually put good legal spend, preventative measures, rather than bad legal spend, which is fixing the problem once it's already happened. Those controls mitigate other risks as well. So when you invest in legal risk controls, you're not just investing in making the general counsel's life easier. The general counsel's life only becomes easier when the business is operating better, when it's more aware of its legal obligations, when it's more aware of the legal risks that it's managing. And one thing that I didn't touch on, and to be honest, it's 20 to 7 over here now, and I've got beer waiting for me. So
we don't want to hold you from the pub.
No, but these taxonomies, right? So it's just I put it in there today just because it's part of what I'm doing. It's part of what. Oh, I'm getting a bit of feedback. So it's part of what I'm doing. Right? Adapting the taxonomies. I'm just going to unplug my headphones.
Okay.
Let's see if
that got worse, actually.
Is that better? Am I back?
That's it. You're back now.
Sorry, I had a terrible feedback, and there's nothing worse than listening to yourself speak. So just one of the things that we're doing at the moment is on data protection, but there are a number of really, really big pieces of legislation that lawyers love. I think, the FATCAs, the Foreign Corrupt Practices Act, UK Bribery Act, General Data Protection Regulation, which is an EU beast that is coming your way.
Oh, great.
The EU are getting extraterritorial, even going to affect us when we leave. But you can adapt these taxonomies to start to pick out specific risks in big bits of legislation that are going to affect everybody, and put the same practices in place for those big bits of legislation. So we've built out a privacy risk framework that complies with General Data Protection Regulation, or that calls out all the articles in General Data Protection Regulation. So you can do the same thing for the Bribery Act, same thing for FATCA, so that you can evidence compliance with those pieces of legislation as well. And it's more of a compliance tool than a legal tool, possibly, but in a lot of cases legal still own compliance, which means that that's actually a really valuable thing to have in your locker. So that's it. I'm starting to go a bit hoarse, mate. I
think you've done a great job tonight, Matt. Thank you for putting this together for us, and I think it brings home a lot of the key points we've been talking about in Chapter 3 about the data-driven approach to risk, and how to manage this in a way that is both colorful and appealing to an audience that's got to try to come up with those preventative solutions. So appreciate your time here tonight with us. We'll see you back again for another lecture in a future class.
Cool. All right. Thank you, Chris.
Thanks, Matt.